The Second Amendment and marijuana. It's been a hot topic in the gun rights community for a long time, and it's not going to change anytime soon, but a brand new decision in the Eighth Circuit Court of Appeals will definitely be part of the conversation going forward. I'm going to break down United States versus Aldo Ali Cordova Perez Jr. I'm just going to call him Perez. It's all about gun rights and marijuana. But before I do that, just a brief message to anybody watching who is still morally opposed to marijuana, certainly in the context of owning and possessing firearms. I want you to remember two things. Number one, like it, love it, or hate it, 44 states have now legalized marijuana for recreational or medicinal purposes. And we can't continue indefinitely where the states say you can own marijuana or possess marijuana, and the feds say if you do that and own a firearm, we're going to put you in prison. Something has to give. There needs to be a resolution to this problem sooner rather than later. And also, don't forget number two, and that is the Bruen case from the Supreme Court in 2022. The Bruen case, amongst other things, said the government has to show historical examples of a similar gun control law on the books when the Second Amendment was ratified to justify existing gun control laws today. And we simply don't have that in the context of marijuana. And so whether you're opposed to marijuana personally or not, I hope you can realize there are weighty constitutional issues that need to be resolved for gun owners in this context. So this case is, again, Perez versus United States government. And Perez was allegedly dealing methamphetamine in Des Moines, Iowa. The cops were watching him, and they watched his car pull into a bowling alley in Des Moines. They surrounded his car with their own cars. The cars were unmarked. The officers were in plain clothes, undercover. Perez said he was scared, and so he took off, and a vehicle pursuit ensued around Des Moines' southeast side. They finally got Perez in custody on the south side of Des Moines. Once the police got him in custody, they found a small bag of personal weight, personal use marijuana in Perez's pocket. They asked him if you have any guns, and he said no guns on his person, no guns in his car, but he said, I have a .22 rifle in my closet at home that I keep for self-defense. Now, you might be laughing about this, drug dealer claiming self-defense. I'm giving you the facts of the case as were revealed in the court documents. It's critical to note that Perez was not violent in any way with the officers on the scene. That's going to come up here in a few moments. In fact, Perez, they said, was jovial. He was making jokes. He asked one cop where he worked out, pointing to his biceps. The other cop, who was right behind him in the vehicle pursuit, Perez asked him where he learned to drive because he could not shake the officer in the vehicle pursuit. So he was making jokes. He was not being violent. He was taken into custody peacefully, at least after he ended the vehicle pursuit. He was charged with dealing methamphetamine, 2 counts of that, as well as having a .22 rifle while having marijuana on his person. The police went to his home, seized a .22 rifle. That was the basis of that charge. It's important to note that at trial, Perez was found not guilty of dealing any narcotics at all. The only thing he was actually convicted of in district court, federal district court, was having marijuana while possessing a .22 rifle. The judge in the case cited U.S. Code 922, subsection G, subsection 3, which says it's unlawful for any unlawful user or a person addicted to any controlled substance, as defined in section 102 of the Controlled Substances Act, to possess a firearm. So that was the basis, the only basis of Perez's conviction. He got a 3-year prison sentence in federal court and immediately appealed his case to the Eighth Circuit Court of Appeals. So that's kind of the facts of the case. Now, there's 2 major Supreme Court cases that are pretty new that kind of govern this conversation. I already mentioned Bruen. There has to be historical examples of similar gun control laws on the books when the Second Amendment was ratified to justify existing gun control laws today. The next case is the Rahimi case from the Supreme Court, 2023. There was challenges in the wake of Bruen about misdemeanor cases of domestic violence. There was no analog, no examples of those in the 1700s. So were misdemeanor domestic violence situations still allowed to disarm somebody for a lifetime. That was the Rahimi case. In the Rahimi case, the court, rightly or wrongly, modified the Bruin case and said that guns could be taken away from people even if there was no historical examples if the case involved violence or any kind of crime of violence. Now, again, Perez did nothing violent once he was detained by officers. So in this case, no allegation of violence, just a blanket ban based on 922 subsection G, subsection 3, put Perez in prison for 3 years. The Eighth Circuit, after reviewing the case, disagreed. They disagreed with the district court, and they have remanded the case back to the lower court for reconsideration and possibly even a retrial. This is a major development in this conversation. What the court said in particular is that you can't just disarm people because they have marijuana. They need to answer a couple of key questions on an individual basis. One question is, did the marijuana use cause erratic or dangerous behavior? That goes back to the Rahimi case, right? Was there something violent in the situation, and did the marijuana possession cause that? The other way of justifying this, according to the Eighth Circuit, is does the behavior somehow classify the person as a special danger? They pointed back to the mentally impaired laws of the founding of the country and said certain drugs may make somebody just blanket so dangerous that he or she could be disarmed just because they have those types of drugs, like PCP, for example. Judge Jane Kelly said, quote, "The proper question is whether Cordova Perez's marijuana use caused him to act in an outwardly erratic or aggressive manner that would, in context, be reasonably perceived as disturbing or dangerous to others." Now, the government argued that Perez's vehicle pursuit was dangerous. He could have harmed somebody else. He could have caused harm to the police who were pursuing him. They argued that was dangerous. Now, of course, it is dangerous. That's not in dispute. What the court said, though, was that you have not proven how the marijuana in his pocket caused the dangerous behavior. Was that pursuit dangerous? Of course. But that is not necessarily caused by the marijuana. They said, quote, "We have already held that without more information, basically, neither drug use generally nor marijuana use specifically automatically extinguishes an individual's Second Amendment right." That's what the court said. They continue to say defining a class of drug users simply by the suggestion they might sometimes be dangerous without more information is insufficient for categorical disarmament. So some major quotes here from the Obama-appointed judges in this case, basically saying drugs by themselves, certainly marijuana by itself, is not enough to take away someone's gun rights. There has to be more behavior that would constitute the basis of that disarmament. But it's not quite so crystal clear. The court also said the drugs themselves may make a person violent despite any outward aggression. They said, quote, "If marijuana caused Cordova Perez to act or drive in an erratic way, for example, he might be disarmed constitutionally under 922 subsection G, subsection 3, even if his outward behavior was not violent in the same way as perhaps the combative hostility sometimes associated with PCP." They're referring to his driving. So Perez could be calm, but his driving could be erratic because of his narcotics, and that might be enough to take away his gun rights. The problem is, nowhere in the trial court phase did the government prove that Perez's behavior was caused by the marijuana. They could never prove that he was using marijuana, and they couldn't find any way to show that his pursuit or any of his behavior was caused by the marijuana. And that's the problem the Eighth Circuit had with this conviction. The Eighth Circuit earlier this year, just in February, also ruled in the Cooper case that 922 G3 cannot be broadly applied without an individual showing of dangerous behavior. Now, this differs substantially from the Third Circuit, which said that the federal government does not have to prove individual circumstances. The Third Circuit said certain drugs categorically make people so dangerous, if you're using them, you lose your gun rights. The Eighth says, nuh-uh, you have to prove individual facts of the case. So this case of Perez is going back down to district court for what could be an evidentiary hearing, but it could also be a full-on retrial where the government has to prove that Perez's behavior was caused by the marijuana that he had in his pocket or possibly in his system. We'll have to wait and see what happens with that case. There's other cases, though, of a similar nature. The Fifth Circuit has recently ruled that any type of a blanket ban on guns because someone possesses marijuana is unconstitutional. That was an as-applied challenge. What that means is only the plaintiffs in that case are covered by that decision from the Fifth Circuit. We also have federal judges in Rhode Island and in Texas who have issued similar rulings on an individual basis. And the 10th Circuit has recently heard oral arguments in a very similar case. They have not yet handed down a decision. So we've got competing circuit courts and district courts giving competing opinions. And that always means it's very ripe for the Supreme Court to finally weigh in. So this issue, whether it's the Perez case or a different case, will likely come before the Supreme Court sometime. We just don't know when. Recently, the U.S. Solicitor General, John Sauer, argued on behalf of the current DOJ, not the Biden DOJ. They said that the constitutionality is not in question, that banning guns from those who use marijuana is certainly, in their minds, constitutional. Sauer said, Section 922, subsection G, subsection 3 complies with the Second Amendment. That provision targets a category of persons who pose a clear danger of misusing firearms, habitual users of unlawful drugs. So they're still holding their same position. If you use any kind of drugs, you're likely dangerous. The courts have come back regularly now and said, no, not so fast. You have to show individual facts of the case. It's an ongoing debate. It's not going to end anytime soon. But if you're a gun owner in the Eighth Circuit, you certainly have some protections, if you want to call them that, for the time being. Much more to come, guys. Stay tuned and we'll keep you informed.